Hello friends, I am Harsh Prabhakar. I am an advocate impaneled with the Delhi High Court Legal Services Committee. In the capacity of a panel counsel, we have encountered many cases with regard to juveniles, and today I have been requested to address all of you with regard to some nuances of the Juvenile Justice Act 2015, which is a separate code in itself to deal with the cases of juveniles. In 2018, the Delhi High Court Legal Services Committee for an outreach program deputed us to visit some observation homes, and then we came in contact with the juvenile offenders. While scanning the records of their cases to see how their cases are being managed and what can be done for their rehabilitation, we found that in certain cases there were some errors which were being perhaps committed by the juvenile justice boards and the children courts in dealing with their matters. So we identified some cases and we prepared the respective petitions which were to be filed for them, and some of them have fortunately been decided. So the first interesting issue which we identified in these cases was that the various juvenile justice boards, while dealing with preliminary assessment in cases of the alleged offenders who were above 16 years of age but minors, that is less than 18, and were alleged to have committed heinous offences which are defined under the Act under Section 2 subclause 33 as offences which carry a minimum term of 7 years. For such cases, preliminary assessment is required to be conducted by the juvenile justice boards to ascertain their ability to understand consequences and other circumstances, to make a value judgment whether they need to be tried as adults. So friends, you would remember these amendments came under the new act after the unfortunate Nirbhaya case, and there was a furor that neo adults who could actually understand the nature and consequences of their act were being treated very lightly under the previous legislative scheme, and therefore these amendments were ushered in. But since these amendments were ushered in, unfortunately the 2015 Act does not prescribe any detailed guidelines how these preliminary assessments are to be conducted, what are the factors and circumstances which are to be taken into consideration by the Juvenile Justice Board in conducting these preliminary assessments. So a Juvenile Justice Board, while conducting a preliminary assessment, is required to take the assistance of psychologists and such other experts. Now, if you see that relevant clause, the word used is may, but the Supreme Court very recently, bench of Justice Vikram Nath, has held that this is mandatory. So this is a very important and a progressive interpretation which has taken place, because otherwise it may have been possible that certain juvenile justice boards across the country may have been conducting preliminary assessment in terms of section 15 of the Act without actually associating such special experts such as the child psychologists and so on. So this judgment, I think we all should read. The judgment is Barun Chandra Thakur versus Master Bholu and another. The citation is 2022 SCC Online, Supreme Court 870. Amongst other things, this judgment also opens very important questions such as the right of fair opportunity before the juvenile justice boards. When we visited the juvenile justice boards in Delhi, where these observation homes in Delhi, and we observed that in certain cases preliminary assessments were conducted by juvenile justice boards, even though they had associated child psychologists in the process of preliminary assessment, but the copy of the reports were not even supplied to the juveniles. Maximum an opportunity to inspect the same was given under the garb of confidentiality. So in this case, we will see that the High Court, Punjab Haryana High Court, I believe, has opined that this is against the principles of natural justice, and surely the provisions of confidentiality are meant for the benefit of the juvenile offender and the victim, and are meant to prevent third parties from gaining access of these records. Surely preliminary assessment can have grave and serious repercussions against a juvenile offender who may then be tried as an adult. and therefore it is our view, and the Punjab Haryana High Court has taken that view, that a copy of all those documents must in fact be supplied to the juvenile offender. In fact, a controversy is pending before the Delhi High Court that in preliminary assessment, what is the nature and quality of this assessment, this inquiry? Is it an inquiry where an opportunity for cross-examination is not to be given, or is it to be given? Because there are divergent views which have been taken by different courts, in fact trial courts in Delhi and different high courts across the country. So in this Barun case, the Barun Chandra Thakur's case, the Supreme Court has approved the reasoning of High Court, wherein the High Court has held, one of the observations of High Court was that an opportunity to rebut the evidence of the child psychologist should have been provided to the juvenile offender, in addition to complete access of the documents which were prepared by the child psychologist. So I would in fact request everyone conducting such cases that we must demand a complete set of the documents which are sought to be used in the preliminary assessment, lead evidence to the contrary, and perhaps request the juvenile justice boards to give an opportunity to cross-examine witnesses, because very serious consequences flow from such preliminary assessments if they are decided against the juvenile. The other issue which we identified was that once the matter was committed to the children's court, then in terms, which is a court of sessions rank, then in terms of section 19, the courts were directly proceeding to frame charges, and there was no independent application of mind on their part. Because if we read section 19, it says that after receipt of a preliminary assessment from the board under section 15, the children's court may decide whether there is a need for trial as a child, trial of the child as an adult, or there is no such need. Now, this requires complete application of mind on the part of a children's court. In our submission, such scheme of the legislature was conscious, and it required the children's court to independently examine what has been done by the Juvenile Justice Board and to come to its own independent conclusion whether such child must be tried as an adult or not. Fortunately, this one of the lead matters, we succeeded before a bench of Delhi High Court. The judgment is reported as CCL LKP versus state. It's a decision of Justice Sachdeva, where he has held this provision to be mandatory, though it is couched prima facie as may, but the court has held it to be mandatory and giving cogent reasons. So this was a success which we got, and then various decisions across different states of India and different high courts they came. And very recently, in I think Shilpa Mittal case by the Supreme Court has also decided in these terms that the children's court must mandatorily apply its mind to this issue, whether a child is required to be tried as an adult or not, irrespective of the conclusion reached by the Juvenile Justice Board. Before concluding, I would just like to flag one more issue for the benefit of the audience. We as lawyers and other stakeholders, when we interact with juvenile offenders, these alleged juvenile offenders who are also ultimately, in most cases, children which were vulnerable to life of crime, and they are actually children in need of care and protection. So we must deal with them with adequate sensitivity and also request other stakeholders to do so. And when we deal with their cases, once the cases are concluded and they are being released from custody of these special homes and so on and so forth, we must take care that they have certain rights under the statute which at times nobody sees. Like for instance, there is section 46 of the Juvenile Justice Act of 2015, which in fact envisages that any child leaving a child care institution on completion of 18 years of age may be provided with financial support in order to facilitate child's reintegration into the mainstream of the society in the manner as may be prescribed. So I would in fact encourage all legal aid lawyers and the Juvenile Justice Board members to effectuate these provisions so that our children, which are the biggest human resource for a country, they can be weaned away from a life of crime and suitably reintegrated and rehabilitated into the society. It is a statutory right for such deserving children, and we must all ensure that the children get their due. Thank you.